5 second. Start. The present judgment will dispose of various applications filed by the Haryana State Industrial and Infrastructure Development Corporation, hereinafter HSIIDC, and others by way of clarifications sought on the judgment delivered by this court in Rameshwar versus State of Haryana, hereinafter main judgment. The main judgment of this court had, after duly considering the sequence of facts and developments which occurred after publication of the notification under Section 4 of the now repealed Land Acquisition Act 1894, hereinafter Acquisition Act on 27th August 2004, read with the final decision of the State of Haryana, hereinafter State, dated 29 January 2010, to not proceed with the said acquisition declared as malafide and inoperative. The decision dated 29 January 2010. The court's reasoning was that the state in principle had decided to withdraw from the acquisition from the notification under section 4, which was followed by the declaration under section 6 and the receipt of objections from the concerned landowners, etc., even when the matter was posted for publication of the award on 26 October 2007. In the interim period, landowners, alarmed by the prospect of losing their holdings, were induced to sell or otherwise transfer their land to colonizers, developers at significantly lower rates of compensation. Most of such colonizers developers had entered into collaboration agreements after the notification under Section 4 sought and were granted licenses by the Department of Town and Country Planning of the State of Haryana, hereinafter DTCP. This court found that upon an overall consideration of the materials, which included relevant official notings in government files, ministerial decisions, and notifications, the state machinery was used to further private ends. The court held that such a decision to withdraw from acquisition was a fraud on power under the Acquisition Act. Therefore, the judgment invalidated all transfers effected from the date of publication of the notification under Section 4 to the date of publication of the state decisions to revoke the acquisition, that is from 27th August 2004 to 29th January 2010, hereinafter suspect period. Apart from invalidating the state's final decision, the judgment also contained consequential direction on various aspects. Before moving further, it would be useful to extract these directions. The present applications have been preferred by HSIIDC and several colonizers, developers, transferees, license holders, as well as associations of allottees of flats or commercial plots, consumers, etc. The primary question which this court has been called upon to answer is as to the nature of the term transfer adverted to in para 42 of the main judgment. The colonizers, developers, and license holders, on the one hand, submitted that so long as the lands were not transferred by their owners, who continued to hold title, mere grant of developmental rights or other associated rights by instruments such as builder development agreements, collaboration agreements, and other contracts, would not amount to transfer within the meaning of the main judgment. The stand of HSIIDC and the state, based upon the opinion of the learned Advocate General of Haryana, on the other hand, was that entering into such development agreements or contracts was in fact a transfer, as it impeded the enjoyment of title by the owners. It was further submitted that such agreements led to issuance of licenses, which were the basis for ultimately deciding not to acquire such lands. To appreciate the rival contentions, it would be necessary to set out the facts in regard to the relevant transactions. Paradise Systems Private Limited, hereinafter Paradise, purchased 2.681 acres of land in village on 7th April 2004 by registered sale deeds. On 9th September 2007, Paradise entered into a collaboration agreement with Messrs. Sunshine Telecom Services Private Limited, hereinafter Sunshine. The consideration for that agreement was rupees 75 lakhs received by Paradise. In addition, Paradise was entitled to 35% share in the built up commercial office space with proportionate land rights and common area rights of the developed property. Paradise granted the absolute developmental right of land for construction of commercial office space. The agreement also recorded that the period for completion of the project was to be 60 months. Based on this collaboration agreement, an application was made for grant of license to the DTCP, and license number 59 of 2009 was granted on 26 October 2009. Paradise alleged that Sunshine did not adhere to the terms of the collaboration agreement. Paradise claims to have refunded all amounts received by it and annulled that transaction by deed dated to 30th March 2013. Paradise thereafter entered into another collaboration agreements with Messrs. Green Heights Projects Private Limited, hereinafter Green Heights for development of the same lands of on 30th March 2013. This collaboration agreement referred to license number 59 of 2009, which was valid up to 25th October 2013. Paradise parted with all rights of development to Green Heights. In terms of this collaboration agreement, Paradise received rupees 28.40 crores as consideration. The collaboration agreement also recorded the liability of Paradise to the tune of rupees 4.25 crores to the DTCP. Both Paradise and Green Heights contend that no transfer took place in the suspect period. It was argued on their behalf by learned senior advocates Mr. P. S. Patwalia and Ms. Kiran Suri. Stop.